All the list বলে দিয়েছি।
এটা পেয়ে দিয়েছি। গোপাল ফর্ম ছিল ফাইলটা চলে এসেছিল পাঠিয়ে দিয়েছি। Yes, all the list.
Lordship, may I have a kind leave to
Mention on
mention?
Monday, please.
Lordship, without leave to file without certificate.
Monday, please mention on Monday. Yes, call the list. Call the
Let's say daily list item number 1.
Yes.
Well, it is that matter where mutual transfer was taken by the work education teacher against another work education teacher. Allegation was that there was a suppression, and Lordship has found there was no suppression. Fraud has not been committed. There is nothing. I have given the letter, documents that I was. That Lordship, at least, if you Lordship to that extent satisfied, then I am entitled to 1 lakh rupee return, because that was only imposed that I have committed fraud and misrepresentation. That document, my lord, of transfer, my lord, although discloses the postgraduate scale I am getting, that order is a part of the transfer application. That is one aspect of the matter. Now, second matter is, my lord, the person who has come from Uttar Dinajpur to Murshidabad, that person, if your Lordship, my lord, set aside the order of mutual transfer, then I am to come back to Murshidabad. But that gentleman, whether, my lord, he is not a party, he is working there for many years in the new place. Therefore, what will Lordship will, how will Lordship will treat him?
Not get the postgraduate scale of pay.
He is not a postgraduate teacher. I am not a postgraduate teacher.
No, you have said for.
I have been given an additional pay for my additional qualification.
That will not be given to you. That you have to return. Whatever you have received towards that, you return it.
Right, I tell you, that is not a challenge.
Then you dismiss it.
Lordship,
Then you dismiss it. That's simple as that.
Let me complete, my lord.
You should not have been given the transfer in the first place. You should not have. It's contrary to rules and law.
But I am in the
If
same.
you want us to dictate, we can dictate, no problem on that.
No, I am in
There was
the.
action for only to find out.
In order to find out, 3 problems have cropped up.
Yes.
One problem is about 1 lakh rupee, my lord, I have not suppressed. Lordship will definitely, my lord, will return me. The pure teacher will get it back. Second aspect, the gentleman who has already joined here. I have not, my lord, reopening the issue which has been argued to your Lordship. I leave it to your Lordship. I have only given the facts to your Lordship. Third is, my lord, I have already taken another transfer on mutual basis to another school in exchange of another teacher. I am no more in the said Uttar Dinajpur.
You are no more in the Uttar.
No.
But you will not be.
That teacher is no more in Murshidabad.
That is neither here nor there.
That
So
teacher is no more in Murshidabad.
Yes.
Now, my lord,
You are not entitled to a higher scale of pay. That's quite clear.
a higher scale of pay was given by the order of court.
Wrongly.
But that order has not been challenged.
Doesn't matter.
Well, it matters, my lord. Because that is.
That 1 lakh will forfeit, either of the two. And henceforth you will not be entitled to any higher scale.
1 lakh, my lord, then your Lordship is to hold I suppressed it.
No. If you are unable to return, then we'll forfeit that amount for the time being to create equity, and then.
No, I have paid the 1 lakh, not return, my lord.
It is
I have paid 1 lakh. If your Lordship returns me, my lord, I will be benefited.
It is with the registrar.
No. Register. Register. That is, however, it is out of my pocket. I am not keeping the money in my pocket. That is out of my pocket. It is no more in my control. I have already deficit of 1 lakh.
You are not entitled to higher scale. That's absolutely clear on this.
My Lordship will not kindly, my lord, be
You are not
that much
entitled
harsh.
to.
That much harsh. Attacking the order of justice by Ashok Das Kumar Dasodhikari, where I have been awarded the higher pay scale. Appeal was preferred, Section 5 application or on any ground, my lord, without going to many, appeal was dismissed. No SLP was filed. But does not it reach finality? Even a wrong order, if passed by the court, my lord, that should reach finality as, under the rule of law is applied. Procedural law is applied. Procedural law, they prefer an appeal. Appeal court, my lord, did not interfere with the order. The order was before the appeal court. Appeal court did not interfere with their order. Lordship was not so unkind, my lord, previously when he moved the order. I did tell you, Lordship. Lordship was very sympathetic, my lord, to the teachers.
Sympathy must
But what
follow-
the wrong did I do?
Sympathy follow where.
I show you, Lordship. But according to law, non-relevant subject, if I acquire a qualification, I am entitled to.
No. Then it has to be ascertained whether that is required for the benefit of the institution.
No,
or
no,
not.
no, no, no.
Absolutely. Absolutely.
Non-relevant subject, not benefit.
Why you should, why the school
That's circular does not speak of.
after 95? After 95?
91 rules say, my lord.
After 95, tell us. After 95 circular, tell us. It is possible or
But
not?
that is
Please
95,
tell us after 95 circular,
nine-
possible or not?
95 circular, my lord, 67 AC, 95
Forget
circular.
about this. We ask you a simple question. After 95
Yes,
circular,
if I take,
it's only in the relevant subject. Read with 12.3 of ROPA.
my lord, that was an issue, my lord. We argued previously with other
Let's
courts.
answer the query of the court.
That is
After
exactly I'm
95 and
answering.
12.3, it has to be in the relevant subject under 12.3.
Otherwise not.
Yes, so you cannot.
Otherwise
you are
not.
entitled to higher scale
But
of
there
pay.
was a provision.
You are not entitled to higher scale of pay, Mr.
I
Bhattacharya.
admit that.
So more you argue, more you in the sinking zone.
To 1991 Rupa, my lord, provides for.
So you will not be allowed to have any increments. Whatever you have received, that will be adjusted against your future salary. You will not have to refund it.
That is not the issue before your lordship. That is not the issue. It is my appeal. It is my appeal. It is not the issue before your lordship. This is not the issue. Lordship will kindly appreciate. As today, your lordship upsetting the order passed by another honorable judge of this court, my lord, sitting singly. What wrong I did, my lord? The government has given it to me. Court has passed an order in my favor.
That's true. Government has given it to you without ignoring that.
No.
How could you ignore that representation where he has enclosed the documents? You have created the problem for yourself.
My lord, kindly peruse annexure P3 at page 19. Over
Yes.
there is no provision or there is no scope for enclosing any documents whatsoever.
But he said so.
He said so, my lord, but
Yes.
this is also an irregular act, my lord. I will show
No,
why.
he has disclosed the documents and you have overlooked it.
There was no question of disclosing documents, my lord. There was no need. My lord kindly peruses the affidavit in reply by the applicant.
No, you see, you are not disputing, Mr. Counsel, that these documents you have not received with the enclosures. You have not said so anywhere. You have not said so anywhere.
My lord, kindly turns to page
Please answer
22.
our query first. We'll turn to everything. You have not denied of not receiving this circular, this letter with the annexures. Have you ever disputed that?
My lord,
Then please answer the query first. Don't nod your head. We want a specific answer from you. We have to
Yes, my
decide the matter. So you have received this document with the enclosures.
my lord, first it went to the commission, not to us.
Whoever it goes to, commissioner, DI, we are not concerned. So he has made a disclosure. And the last page where these documents are there, there's a seal of the office.
My lord, the seal is on the top of it. After that, they
The
have
seal
written it.
is here. Please have a
Yes,
look.
my lord.
Either
After
you have
that,
to print the copy or over the- Come to page 60.
60, my lord.
Yes. So you have received this document with the enclosures.
My lord, it's not there in my document 60.
Hey, दादाओ को document दादाओ. You have created the problem for yourself.
My lord, in the paper book.
See the document. See the document for yourself.
না, না, কিন্তু আমাদের এখানে 60 এটা নয়।
So there cannot be a separation if these documents were there. Can there be a separation on this? You may have taken a wrong decision. You have overlooked it. So overlooking doesn't mean separation.
My lord, after receiving, they have mentioned in the handwriting over there at the bottom. The receiving
Is he
stamp is
saying
on the
it is
top of it.
formal document?
What?
What is
My
saying?
lord, after receiving the form, they have
Yes.
mentioned over there by handwriting.
Yes. This was received by you, isn't it or not? So entire document has been received by you. You have not denied that they have not disclosed, they have not submitted this document. So after this document is there, then your decision was erroneous, for which he cannot suffer.
My lord, kindly
So there
subject to
is no
Dr.
suppression on that.
My lord, subject to Dr. Patra's opinion and approval. My lord, the first is the
Please,
duty
Dr.
of the
Patel, tell
commission.
us. Tell us.
This application, it is addressed to the commission.
Correct,
And the rubber stamp, also the receipt is naturally that of the commission
correct,
at page 22.
correct.
Now, whether these enclosures were there or not, that I will have to check from the
That is,
record.
that
I
is,
am
the
not
that is the
disputing
reason we
it,
kept it.
because the result of this application culminated in an order for transfer.
If these documents are there and if you have if you have interpolated it, there's one thing. You produce the original document, we shall see to it. You produce the original.
I may check it. I will
In
come
another
back to
document of
this. Produce the
Rajiv
original.
বিশ্বাস, there is no enclosure. কিছু নেই এবং স্ট্যাম্পটা এখানে।
এটাই প্রমাণ করাচ্ছে এটা যা
এটা-
Then there cannot be any suppression,
এটা
Dr.
option
Patra.
ওনাদের। reply,
reply.
their reply, the appellant's reply.
এটাতে
In the appellant's reply, the document is looking different. There is no mention.
Produce the original, we'll go by the original. If
I'll-
it is not there, we'll dismiss with whatever the cost is
Yes,
there.
yes.
Absolutely.
Yes.
You produce the
With
original.
additional cost, bow down to your lordship.
You produce the original.
I
That will have,
cannot come with clean.
because Dr. Patro, if these documents are there,
অন্য ক্যান্ডিডেট রাজীবের, not my application.
রাজীব বিশ্বাসের সঙ্গে।
Let me check the original records.
That
But
was
what I
Rajiv's
would like
application.
to
Why you are
submit-
confusing
what I-
that?
What I would like to
see, if in
submit,
the original record this is there, and then you have taken a decision, then they are not to be blamed for that,
no, but the
even if they are
question,
not entitled.
no, the question is different, because each authority has a separate role to play.
Correct.
Our role is to issue a transfer if we find the two candidates are matching.
Correct.
If we go by their qualification, which is disclosed,
They're not matching.
no, they are matching. They are matching.
No, they will not be matching if you take the enclosures documents.
Yes.
Then they are not matching.
Yes, they are not matching. but-
Correct.
But the enclosure is normally given to justify the statement made in the,
Correct.
if there is no
You have a right
statement,
to-
that,
you
that enclosure is valueless.
Dr. Patru, you have a right to verify.
Yes,
I may have given declaration. That is why the verification.
yes.
So you have
But I
to,
verify the statements. If you have given additional annexures, I
no,
don't,
you have to consider it, that whether on the basis of these documents, he is
he is
eligible.
not asking for any benefit because he has not mentioned it
No,
in the
he's asking for,
application.
he's asking for mutual transfer.
Yes,
Correct. Question is this, if he has acquired higher qualification, then whether the qualification of his initial acquiring, that is B or whatever is there,
that,
or the qualification he acquired by reason of, by passage of time and with the approval of this, will be taken into consideration for the purpose of deciding his eligibility for mutual transfer or not.
it will not stand in the way. That is my respectful
Then
submission.
that's
Why?
fine. There is no, then,
Why it will not
no,
stand?
then there is no suppression then.
Even if there is no suppression, the question
Yes.
will then come whether he is entitled. So
Entitlement,
I have disclosed everything. Am I entitled?
see, entitlement has been decided by you. He has not decided.
Yes, we have decided, and we have decided, our decision is reflected in the order of recommendation, page 23.
Yes, then,
And what is
Then-
shown here
yes,
is that both the candidates are of the same designation.
correct,
Their status of the candidates will be on the basis of the post in which they were recommended
correct,
and subsequently approved by the government.
correct.
Now, by virtue of a higher qualification, if you are enjoying a higher pay scale, that does not change your position as the post against which you are working. You are only going to get the monetary benefit. The post remains the same. So that is the basis on which the transfer has been issued.
Correct.
Now, the question is with regard to the judgment where the court has allowed the higher pay scale.
Higher pay scale, correct.
Here, I will not go into the legality of such a judgment, because if the court has come to the finding, that is the judgment.
Yes.
But my submission with regard to that judgment is this, that was a conditional, was a conditional order. My lord kindly sees the judgment, what was the observation of the court? that school was utilizing the teacher for those additional qualifications. That is why the court said so. Kindly see page 71.
See, today we are concerned with Dr. Patro, the order passed by the learned single judge.
Yes,
Learned single judge said that they have suppressed material fact. It does not appear from the enclosures that they have suppressed it. They have given whatever they have to say. Now, if you have overlooked these documents and still you permit transfer, then there is no suppression. Because the order impugns
no, but I'm
says,
saying that I have,
no, the order impugns says that this has been, you made a suppression that you are postgraduate. That is the reason for which,
post-graduation is the qualification.
yes, no,
But
that is
the
the basis
post
of
is
the order.
to be identical.
But have you seen this? Please see the order. On perusal of the said
29.
provision, it reflects that the ingredients of mutual transfer are that the person should be in the same post and should belong to the same category. So,
Yes, they are in the same post, same category, but one is enjoying a high.
no, admittedly, in the instant case, the petitioner cannot be said to belong to the same category. So this is contrary to what you are submitting. This is contrary to this finding of the learned single judge, is contrary to what you are submitting. Because the learned single judge said, admittedly, in the instant case, the petitioner cannot be said to belong to the same category. Further, the petitioner has not come with clean hands under such and such. This we do not know why this should come at all. Why they are not in the same. If you say that, because you are saying they are in the same category.
Yes,
They are in the same category, but they have obtained an incremental benefit because of
higher
higher.
qualification.
So higher acquisition of higher qualification will not take away the basic qualification they acquired and where they were functioning. That is your submission.
Yes, yes,
If that be so, then this judgment is not sustainable.
yes, that
This
is,
judgment
that
is not
is
sustainable.
correct. I am not saying it is sustainable. I am not saying that. But what I'm saying is that our consideration for transfer, that there is no mistake in that. It might happen. I'm working in a
No, but
department.
Junior was arguing that was he suppressed. He was supporting this
The
judgment.
state, not
State, yes. State is saying there's a suppression. Suppression would only occur provided these documents are not on record. If this,
that I don't know. That
No,
I have
first
to check.
thing- first-
My
yes.
learned friend is saying I
Suppose-
should give some credence. He must have seen
No,
something
so-
or checked something. And let me.
no, but then what is the consequence? Even if suppose he said these documents are there or not there, but what you are submitting is diluting his submission, because you said that notwithstanding him acquiring any higher degree for the purpose of pay scale, his basic would remain, and that can be considered as a category for the purpose of deciding his application for
Yes,
transfer.
the post against which his service is approved.
Absolutely. So his post is approved for.
It's identical.
So this
So
is
the
same post.
transfer is good.
So transfer is good.
Now next comes the question of the higher pay scale, which is
Higher pay
not
scale,
my arena.
Yes, but higher pay scale, unfortunately, a single judge passed an order,
Yes,
and that has been, I think, that was appealed against.
that I'm not.
My lord, may I interject over here? My lord, the duty of the commission is merely to recommend the transfer
Correct.
after verification. Now the approval authority is the DI.
Yes.
And the DI would do that. Subsequent, the transfer has been effected and final approval will be given by the DI upon scrutinizing the documents. And that is where this whole thing, this error, when noticed. When the documents were scrutinized by the DI, all these documents that the petitioner was drawing postgraduate pay scale.
Fundamental mistake. You are making a fundamental mistake, because what Dr. Patra has said, the category would remain the same because he was approved for that post. He was not approved for any higher post,
Correct.
but only he is getting a higher pay scale because of his increments under the prevailing, maybe the before 1995.
Rightly or wrongly, the order is there
Yes,
to give
and
it,
there is rightly or
which
wrongly
was
there is an order,
accepted.
and that has attained finality. You
Yes.
cannot touch that order. So where is the question of suppression? Because the learned single judge has proceeded on the basis that the category are different. So if the category is not different because his post was approved for the work education or whatever is there,
Yes,
and he is transferred to a corresponding post where the same post,
Work education.
work education, then there is no irregularity in that.
My lord, that would have been just a mere oversight by the commission.
no, we are not calling it an oversight.
No, you are not following what Dr. Patra is saying. It is not an oversight, it's a conscious decision. Because his post is approved for the work education.
My
And
lord,
to understand his fundamentals.
the only question which now remains is whether that higher scale which he was enjoying, whether
But
that
that
will
is-
also be carried along with his service. Now, if we go by the judgment,
That we
he will
cannot
get
touch.
it. If we go by the judgment, if I'm to be
We cannot
candid,
touch it. We cannot
yes,
touch
if
it
I'm to be candid and fair, my own personal opinion not
because
is that he should be getting it.
because that order has attained finality.
But the only thing which I tried to point out, if I was actually contesting this case, I would have said that this was conditional because the court was very specific. That the school is utilizing your service
That is the thing.
and the
So here there was
students
no
are
contest.
benefit. So that was a
Now,
So-
to that extent, I agree with you because that was higher scale of pay because
that
he was
can really
taking
be the only ground for
increments.
curtailing it now.
increments. We also feel that increment should not have been given to him, but we may not direct refund of that.
No, that service has been
And but
used.
it will be stopped from now onwards because his post is approved for that.
Yes, and in the new school, they might not require or they
Yes,
might not
absolutely.
utilize his
Take down.
other degrees.
We have heard the land council for the parties.
না না আর এই judgment
আমি একই কাগজ ছাড়া কিছু নেই।
Yes, call the list. List number 2.
But item 2, my lord, only my lord,
Yes,
a order of his lordship and this, except that I have received nothing. I know nothing
that
about this
is-
matter, my lord.
number 2 is for the Union of India.
I'm appearing for the Union of India,
Then-
Lordship. Lordship, what has been served? Yes, your Lordship's order. I need just,
Milord,
I was looking for some details if I don't know whether my learned friend could
No, but
give.
you have not received the.
I've received a copy of the order, Lordship, but disclosing whether selection process initiated. Lordship, could my learned friend give some details, the year or something like that? I think it'll be easier to find out. The period or something. I mean, otherwise there is, I don't have. a
Because you have to find out, obtain instruction with regard to the order of 3rd August.
Order
Third
of
August,
third
right?
August.
I have filed
We
one.
direct the respondent number
Yes,
3
yeah.
to file an affidavit disclosing whether selection process intimated for filing.
No, Chief,
This-
that
this
is, I mean, could my learned friend give some papers? I mean, the period or something like that. I don't have a
No, no.
scrap of paper.
His case was that
Ah.
he earlier applied, then there was some litigation. By that time, the chair, that period of tenure expired. So they initiated, I think that university, foreign university, initiated a fresh selection process. His case is this, I am the only eligible candidate, so my case should be considered. That is his case. Now, the writ petition was dismissed. Writ petition was dismissed, so before us, since no one was appearing,
Disposed of.
Lordship, could I, that
With
is what I'm saying,
instruction.
if I could get a copy of the petition, Lordship, it'd be easier for me to.
you have copies of the
track-
petition.
I don't have.
No,
any
I don't have,
paper.
Milord,
Anything,
yesterday I have
anything
filed
that
one
I can.
can. Unless this can is disposed of, the filing section has given me date of 30th August for this. I am paying, let it be put on 5th
But have
because
you
I have,
served them?
I have to
No, I
file.
don't have a scrap of
I
paper.
have
That
to
is why,
file
Lordship.
affidavit in service, etc., etc.
I
No,
need
no,
some
you serve
details.
them,
I
so
need
you need
some
not to file an affidavit,
details.
sir.
No, it is
Now, what
already,
is the can? What is can?
can is for modification of order of 3rd August 2023, 3rd August.
For,
Modification.
Some modification.
I see.
Unless that is cleared,
Very
main case cannot be proceeded.
Lordship,
the-
if
the
he
prob-
gives me, Lordship, if I can get some details, Lordship, otherwise it's very difficult to track down, that is why. To pursue the matter.
Let it be fixed on 5th September
5th
and the
September.
main case can be discussed.
Now, unless and until, my lord, a copy has been given to us, my lord.
Very well. You have copies.
No, I don't have anything. I have
You have to make
already,
copies and give it to them.
on 26 July Court, Honorable Court Division Bench has recorded that all my service is totally complete. Everything is complete.
Yes, served, no
Then-
doubt about
oh,
it.
yeah.
Yes, served. You obtain
I have-
copies from the
I have
department. He's appearing in
Served
person.
on respondent.
And I don't know which department also, my lord,
Lordship,
nothing has been,
Ministry of Culture,
only, my lord, only, my lord, this document has been given from the GP office. Nothing else, my lord.
But yes, served.
I do not know whom he has served.
I have served on
could
respondent.
we make a copy, Lordship, then I'll have to go
Since you
through
are
the
not my
records and
respondent,
find
I
out
have
the
not served on
details,
it.
Lordship. That
You are
is the
not my
problem.
respondent.
Shono.
If some kind of,
Let it
some
be fixed on
details-
5th September, my lord.
Lordship, if we could even go through the, I mean,
Lordship.
some details are required, Lordship.
No, but this can you require to
No,
serve
can
them.
he hasn't. served.
Can, my paper is ready.
Your paper, which paper? এই একটা পাতা একটা চিঠিতে।
Can application, you have to serve
Yes,
him.
yesterday I
But-
filed it.
No, but
Today
you have copies.
কপিটা
Huh?
দিন আমাদের,
You have
কপিটা
copies of
আমাদের
this
দিন।
can
Please
application.
not with me. Hello.
You have to serve this copy of the
I
can
know, and
application.
then I also filed affidavit of service also.
And where
Have
is your
copies or
paper?
not?
Where is the application?
Scanner application.
You have copies of this can application with you or not?
Not,
Then কি
Then
file
you
করেছে?
should have served.
I have filed in the filing
That you have filed
section.
one copy, you have
And
to
I'm-
serve
I
them.
am ready to send it by post. That is here.
Why you
হাতে
require to
দিয়ে
send it
দিন।
by post when the advocates are
আমাদের হাতে
appearing?
হাতে দিয়ে দিন, আর দিতে হবে না।
You want your matter to be heard or delayed, that's why why don't you serve them?
Let it be fixed on 5th September.
No.
my lord. Nothing
It
is
says
with
it
me.
cannot be.
Nothing is with me. I have not brought.
No. The application has to be fixed.
Yes, but 5th
Application has to be disposed of. This can.
আপনার আমাকে হাতে হাতে দিয়ে
That
দিন।
is
This can is not
That
disposed of,
is
sorry,
what
we don't
the
agree with you.
Lordship is saying.
Don't agree with you that's disposed of. You have to serve this. Take down.
On 5th September, let it come up in the list.
Lordship, let it be directed to be served upon us. Otherwise, if
You
you
have
send
filed
it
your,
by.
you have filed your, but while he will serve you, that is a problem. He is
He'll
appearing in
submit it
person.
I'll give him my number, he submit in the bar.
No,
and
no, I
all.
cannot serve on anybody. My lord, I have got past.
No, you have to serve them.
Know that I have got past experience until and I'm sure that the gentleman he's representing the,
Yes, we are recording it, what we are doing. We are not doing a circus.
my lord,
You
earlier
have to serve them.
I was charged by the respondents, authority in their.
Whatever is there, you need to serve them.
Certainly
Once
I
they
have
are-
to
once an
serve. I know
advocate is
that
ap-
process.
Once an advocate is appearing and assuring, you have to serve him or her.
Certainly
No.
I will serve,
Stay down.
but his identity must be clear to me.
No, not
On
to you.
whom I'm serving,
Not
on
to you,
whom.
to us. Identity is not too clear to you, to us. Their identity should be disclosed to us, not to you.
Well,
When
No, that I've been appointed by the.
I'm submitting
Additional
before the court.
Solicitor. I have been appointed by the Union of India to appear. So that is.
Sure. we direct. We have recorded the names.
কোথায় দিতে হবে তাও বলে।
Next, madam, please.
Item number 3.
Item number 3, I am for the still respondent.
Lord, I am for the Lord appellant, my lord.
As per Lordship direction, I have filed the compliance report.
আমি কিছু নম্বর কোর্ট থেকে নেব, যা অর্ডার থেকে নেব, ঠিক আছে? আপনারা কি
This is my compliance report. And also I serve the school authority by, this is the track report.
Well, lordship, kindly see the my lord order dated my lord 10th August 2023, my lord.
My lord, I pray for short passover as learned Senior Toli Bhattacharya is standing on a legs before
No,
court number 18.
It's a compliance of not by you. You have complied with. The headmaster is present.
I don't know, my lord. I serve before the school authority headmaster. This is the track report, my lord. Item is delivered. এইটুকু দিন না।
You are for?
I am for the state authority. DI.
Anyone representing the school is present?
No, no. The school not present.
Because the headmaster was right to be present with complete report with regard to requisition given to the district inspector of schools.
The school authority did not send any requisition before the DI, my lord. Till date.
Well, the school authority have also not lodged any complaint before the board.
My lord, in the meantime, my lord, my client got a notice from the, my lord, disciplinary authority, my lord, to appear before the disciplinary authority on tomorrow, my lord. And my lord, in the order, my lord, they have stated, my lord, in terms of the order dated 20th July 2023, passed, my lord, by in this appeal, my lord, there is nothing, no such order, lordship kindly see.
No, my lord, there was a direction
Yes,
upon the
sir,
board.
direction.
Board was instructed to take instruction in respect of the steps taken for disciplinary proceeding. Well, at the starting or initiation of disciplinary proceeding, your lordship, as per rule 5, there must be a formal complaint before the before the board, either by the school authority
So
or
there is no complaint.
there is no formal complaint. But my lord, as this matter is going on, so my lord, that is the reason we have sent a letter to the concerned school and also to the concerned DI to forward if there is any complaint against the petitioner. And well, thereafter, the system would have been that would have issued a show cause notice. But well, in this case, we have sent a letter and requested him to appear in the hearing, and also the school authority and the DI to go into the matter.
But my lord, only 1 month salary, my lord, as your, my lord, only 1 month salary was given, my lord.
Salary part is of the school.
School authority.
Yes.
But the disciplinary proceeding, because of the unauthorized absence, that portion cannot continue so long we are hearing the matter.
We have not yet initiated the proceeding. Before initiating of the proceeding, we have sent a letter to the petitioner, the
Because
concerned
the
school,
initiation of the proceeding is on the basis of the order passed by Justice Mantha,
lordship,
because of the unauthorized absence.
absence.
Now, whether the unauthorized absence can be regularized or whatever is there, or whether any disciplinary proceeding should be initiated or not, that's a matter to be considered by us. So long we are considering the matter, the question of issuing any disciplinary.
No, we have not, we have
No, no,
not.
no. The school also could not have.
School does not initiate proceedings. School can always
Ask for
lodge.
permission.
No, school does not initiate. Malab, that was in the old rule.
School seek a permission.
No.
Then
Malab, that was the old
That
rule.
rests with you. That rests with you.
That rests with me, your lordship. School can only make.
So what is your view on this? Should the disciplinary proceeding be continued? Should be
Well, we have
initiated?
not yet initiated. What we have done, we have asked.
So what is your view on this?
Well, disciplinary proceeding must be there. If your lordship permits.
That's, you see, question is this, if there is not unintentional willful is one thing. He may be a victim of circumstance. There may be so many reasons. So you have to take a conscious decision whether the disciplinary proceeding should be initiated or
Should be
not.
initiated or not, only for that reason, my lord, a hearing has been called for the petitioner, the school authority and the DI to appear to submit all documents so that board can go into the matter and decide whether disciplinary proceeding must be initiated or is it necessary to be initiated. Because now everything is not clear before board. Because we are not having all the relevant documents.
No, but how you are agreed by this order? We can only say that if
No, my lord, no salary has been, my lord.
no salary will be released. That is no part of it. But so far as there will be a break in service or
Yes,
not.
sir, we have challenged, my lord, it in the appeal.
So since the DI will be considering, we'll set aside this portion of the order. Because the DI will, if the DI approves that there is no break in service. So that portion of the order we set aside, and the payment of emoluments have not been paid.
No requisition sent to the DI by till date.
Has this order been communicated?
My lord,
Yes, yes,
Lordship, my lord,
I have communicated.
please to direct to the state, my lord, to
Correct,
communicate.
correct. Item is delivery.
My lord, in two occasions, my lord, Lordship was pleased to pass this order, my lord.
Take
Two
down.
occasions. And my lord, only
Write down
1 month salary was
the
given.
communication of the order dated
There is no other allegations, only an,
I think it should be sorted out.
yes.
If there are some reasons, you make her for timings, you don't
And
pay
when-
her, don't pay her for few months,
Lordship, we are not in a hurry.
but come with suggestions so that we can all dispose of the matter. That is the thing. Going through the record also tell us that what should be the proper mode.
My lord, here, when there is an unauthorized absence, it is upon the school authority, managing committee of the school, to take a decision in a resolution whether they approve is as an extraordinary leave with pay or without pay. And then they send it for approval of the board.
But that has not been sent to you.
No, because there is has not been sent to me till date. And unauthorized absence is also a ground of misconduct. For that, proceeding can be initiated, but
Yes,
we are
that's
not on that at present moment. So
At
that
the end of the day, you will be the disciplinary authority
Lordship,
on the basis of the recommendation of the MC.
yes.
Grateful one.
Yes, next.
Appellate side daily list matters appearing under the heading application 3, item number 124.
Yes. Yes, is that environmental science and environmental studies? Yes. So what is, Mr. Chakraborty, what is the stand of the
Actually, I
university?
tell you, environmental studies and environmental science was same discipline. In fact, I tell you, in a similar situation arose, whether business administration and political science the same discipline or not. Matlab, actually, UGC is the proper part. UGC by 2019 made compulsory environmental studies. Syllabus also, because political science is not a science, juridical science is not
But
a
if you
science.
see the syllabus of environmental studies and environmental science, they are different.
No,
Different syllabus.
most of the subjects are same.
No.
Most because there is a practical, because Rabindra Bharati University, Rabindra Bharati University, because as there is no science faculty, that's why nomenclature, unnatural novel studies. Now UGC what did it? UGC by 2019 made UGC environmental studies a compulsory in undergraduate and graduate. Therefore,
You advertise for which post?
environmental studies same discipline open post.
If you have made environmental studies,
That is open post.
yes, so environmental studies is there.
Uh,
Then what is given is for the environmental studies is the Master of Arts.
Yeah, master. No, master of, because master in the advertisement is clearly stated this is open post. It's open. It is a
Question is whether they're equivalent or not.
yes, definitely.
No, but one is if environmental studies.
Well, that is the reason why I'm telling. That is the reason because environment in Rabindra Bharati there is no science faculty. There is only arts faculty. That is why name is given studies.
There is no science faculty.
No, that is the problem. That is why he is this, and he got his master from the distance education. His result is very poor. I'm not on that point. The point is that in Rabindra Bharati University there is no science faculty. That is why this unnatural, the name is given in studies, and that is why it is made open.
No, you see, if you find the candidate to be not up to the mark, that is a different issue. But if she has the qualification.
Well, all experts who are present, they are all expert on environmental science and environmental studies. Kindly see the name of the expert. So we cannot say that whether the university environmental study or environmental science is different. Kindly see who are the appear.
No, we are not on that. We are not on that. The challenge is.
My lord, pass this order only of the LGD. You will find, my lord, the learned council for the university has prayed for time to file affidavit clarifying clarifying the petition as indicated in the order dated within 1 week from
the affidavit filed before the court below, it was clearly stated that was part of this appeal.
But
in 4.4 you have said that the UGC produced environmental studies for undergraduate courses for all branches of higher education.
ওকে নেয়নি কপি, ফোন করা হয়েছিল, উনি বলেছেন কোর্টে দিতে। কপি দাও তো, কপি কপি।
কপি কোর্টে দিয়েছেন?
হ্যাঁ হ্যাঁ
করে দিয়েছেন।
It is subject is different, science and arts.
science name is that. That is should have been made UGC
It's a
party.
notification for inviting.
Only UGC can throw light whether it's the same or not.
How? আপনি আগে
The
আগে
party, you just is a party.
No, that is why, my lord, UGC is not a party. My lord, in 2020, the things are
Because
doing
you
some
see the
normal.
Syllabus are different. Some subjects may be common.
Well, that
Some
is,
subjects may be common,
but
but the
according to
syllabus is
UGC,
different.
well, why have they- but in 2020, a similar arose before the Supreme Court. 2020. And Supreme Court said in such a dispute, UGC should be made a party. Otherwise, UGC can only throw light and assist the court. Because whether in, yeah, first of all, I'm not talking about his result, his performance, I'm talking about.
It is for even for future.
That is there. That is there.
You'll be in trouble.
And that's why let the UGC be a party.
They have not made UGC a party because they are the court. They have set down the courts. We must make the UGC a party.
not
So about Mr. Anil Gupta.
my mind it is not a
UGC is a competent person, my lord. They should be made a party.
it is a
You
transfer.
made a party
agreement,
again.
I am not I am not in the earlier petition, my lord. It's a transfer.
Because UGC has to throw a light on this.
My lord, that is
Because
there.
there has to be uniformity all India, pan India.
Because that is why, my lord, in 2019,
That take down. Fit or unfit, that the body will
What's it?
decide. We cannot decide. We don't have the expertise to decide.
Bylaw can see is violated.
First question. No,
But it-
Item number 125.
Weeks. 125, I am for the respondent led by Mr. Bhattacharya.
Yes, this for the appellant.
My lord, I'm for the appellant.
Memo happy.
Sure. Now, my lord, before my learned friend opens, I would request him to, my lord, produce the order passed by the commission on 26th September 2022 in compliance with the order of the learned single judge. That is important.
My lord, this is the 2 copy of the order which was. This is the order, sir. Sir, this-
It's not a part of the pleadings, therefore it is necessary.
Yes. So as a special case, it was allowed.
No, it was not allowed. The court rejected the reasoned order and the court passed a mandatory order on the basis of its interpretation of which we are, the reason for which we are now before the court. That interpretation of the rule, it not only disrupts the entire selection process, but at least according to us, subject to what the division bench holds, that was not the correct interpretation. So the decision on the law point is what we are here for. Besides that, one more other vital point we are taking, whether the court will entertain it or not, I don't know. That is, the court passed the order without the jurisdiction. So that order is otherwise a nullity. Because
He is not the writ petitioner.
no, the writ petitioner was one Bobita Sarkar. She had come before the court against a candidate who had superseded her by rank jumping. And she got all the benefits. She got the employment. She got the
The grievance of Bobita Sarkar and the grievance of these writ petitioners are
not connected at all. Not connected at
but
all.
she was not also the writ petitioner.
No, no, no. Then after giving all relief to the petitioner, all possible relief, including the salary of the other candidate was entirely handed over to the said Bobita Sarkar, the writ was kept pending. And this CAN application was filed. We raised objection. That is a totally different cause of action.
But difficulty is this, that you have acted upon this order. That is a problem.
No, but the point was taken. The point was
But
taken.
you have acted upon this order also.
No, we did not act upon this order. This order was not accepted.
Yes.
No, you have acted upon the order, you passed an order.
You have acted upon the order.
Yes,
passed by
the final order passed by the court.
So after you acted upon this on this order,
No, we are before the court. We are not asking for anything with regard to the,
no, we would have followed if you have immediately come up before the saying that we appreciate that if she was not the writ petitioner, then that cannot be unless he may be arrayed as a
Arrayed as a party.
writ petitioner.
Arrayed as a party petitioner.
He has a separate cause of action. Try to understand this. How he
and the
can be
court
tagged
did
with-
not have the
how he can be tagged
determination
with a
at that
party?
point of time.
It's beyond the principle of addition of party under the Code of Civil Procedure. Then only one person will file a writ and all others having, they say, I have some interest, come and get added. Under
That is what is
principle?
happening against this particular writ petition.
What
There are
jurisprudence-
several addition of parties, different cause of actions. They're coming up before the court.
Mr. Bhattacharya, under what jurisprudence it is possible?
May I,
This has
I
to be decided between the whatever he raised, and then anyone, we are, it is not, otherwise it has to be a
Mulad,
order 1 rule 10.
Mulad, the issue, yes, it has to be taken as order 1 rule 10. The issue was not Milord per individual per se. Issue raised was about Milord the process and procedure of selection. Therefore, everybody is affected, filed an application.
No, the persons who are before us, rather the added applicants,
Yes.
they cannot have a same cause of action as Bobita.
Milord, they have the same cause of action. Cause of action of Bobita was, Milord, about the mismanagement of the panel. This was not an individual that I have been superseded.
No. It's a question of the writ petitioner's case and this person's case may not be the same. And
Milord,
then
they were same. They were same on the principle of interpretation of, Milord, the preparation of panel.
that's a different issue. That has to be dealt with independently, cannot by this process.
No, that procedure, Milord, may have some Milord, doubt in the mind of the court.
Court may pass an order because this is an order in, it cannot be an order in rem. It has to be order in personam. Unless one makes an application for under order 1 rule 10, it is possible, add everyone correspondent, then you file an affidavit and follow a procedure.
Milord,
It has to be followed.
I follow, my lords, Milord, the anxiety. Milord, the strictly order 1 rule 10 was not followed by of application. Milord, the parties affected approached the court. Therefore, the court had to take the matter into consideration.
The main writ petition is disposed of. The main writ petition is disposed
No,
of.
it was not.
No.
Full benefits were given
It
to
was not disposed of.
Writ petition was kept
But
pending.
that's why the court directed the commission to reconsider. The
Yeah.
commission now considered it.
And the
Commission having considered the same without questioning the order.
The question is this: you have not challenged that order. You have acted upon that order.
Yes, that part we have acted upon. But we had objected. That is also recorded in the order.
Yes, it's recorded that you have said that, but then you have acted upon this order. You could have preferred an appeal. Because the case of Bobita and the case of this added are on a different footing.
Are
on a
on
different
the same footing with due respect.
It's a
Question of the interpretation of the rules.
criteria, an action is wrong. I may say the action is wrong for A reason. I may say action is wrong for B reason. So it cannot be clubbed. I have a grievance against a particular action on which you may not have any grievance. You may have grievance against C. So
No.
I have to there have to be a joinder of cause of action or there are a joinder of parties. These principles have to be followed.
Milord, I abide by, Milord, whatever the observations fall from the court. But Milord, here the court has, Milord, proceeded on the basis that this is a cause of action in rem. And that was not objected to.
Mr. Bhattacharya, how it can be a cause of action in rem unless you make it order 1 rule 10.
No, that technicality is apart.
There has to be a procedural thing.
Milord, I accept. Milord, order
Before the learned single judge.
Milord, may I just tell you, order 1 rule 10. The order 1 rule 10, Milord, invites, Milord, the intending parties to join. Here,
Yes.
Milord.
So Bobita did not want that other parties are to be joined. She doesn't want a representative cause of action.
She did not want.
Everyone knows what would happen today in the midst of hearing a matter. I pass an order, then others say said, I have also a cause of action, so I may be added. It has to be a similar situations. Addition of party cannot, yes, court has the enormous power, but here the cause of action of Bobita and cause of action, these persons who have been added are not the same.
No, Milord, they have, Milord, Milord, similarly interconnected. May not be same, but similarly interconnected. If your lordship goes to the matter in detail.
You are not serious in what you say.
And Milord, that's why the commission, Milord, had accepted the order and acted upon. The commission failed that there is similarity.
There has to be, otherwise the code of civil procedure, we should dispense with.
Milord, in each proceedings, Milord, the always strict procedural of code of civil procedure may not apply. The
Yes,
constitutional court has, Milord, independent.
By reason of procedure, our REIT rule says rule 26. Have a look at rule 26.
Yes, I have seen.
25.
It may follow. REIT code may follow. Not that about, no doubt about it. But what was the issue here? All these CAN applications were hard.
Okay. Today, may I just make one suggestion, one submission? As far as my pleadings are concerned, what I have filed before the court, my reasoned order is not on record. The order which was, yes, I brought 3 copies, but it is not on record. Number 2,
Give a copy,
the order, I thought
I have given 2 copies.
No, you have given 1 copy.
well, Let-
If this order is acted upon, Mr. Dr. Patro,
And independently, my lord, considered.
this order,
I might fail on the fact that the question with regard to maintainability, I don't mind failing on it. I also don't mind failing on the fact that she has joined and she is working. But that interpretation of the rule, that too after a selection process was long over and the panels expired in 2019, when that interpretation was followed for the entire selection process, not only that selection process, all other selection processes. That is very dangerous now because we are facing a series of writ petitions, all coming up with the expectation that that interpretation should be followed for them. So at least that little bit of clarification that no, that was not the interpretation. It is on a very interesting point that you belong to a reserve category. You
My
enjoy.
lord, my lord, may you please to observe that the order was passed as a special case that it was observed by the commission itself. It may not have any, precedent.
Whatever fell from the court, we came back with a reasoned order agreeing to do it as a special case.
no,
Court said, please, let me just finish.
no, Dr. Patro, just
Very
one
good.
thing. This is, so far as this is concerned, it is done and dusted.
My lord.
All that we can say, the interpretation here on 12.6 and 12.7
Yes.
is kept open.
Yes.
Kept
And that's
open.
better.
Since in this case, it has, the commissioner maybe in view of the direction has called it a special case, it will not be treated as a precedent.
Yes, yes.
But the court
That is
did
the best course.
It says so.
very well.
And the interpretation is left open and not conclusive on this.
Yes, yes. Well, that is the best way out of doing it. That it will not create any precedent.
Because you see what happened, you should have immediately preferred an appeal. And the commissioner has acted upon on this, maybe in the face of contempt, could be, we don't
No,
know.
there was no contempt.
I do not like to make any submission which would
Take down,
criticize the institution where I am working.
listen to the order. Is one candidate or two candidates? One.
One.
In a writ petition filed by one Bobita Sarkar, one Priyanka Shaw made an application for addition of party,
Yes, in the same application, addition of party and appointment.
for addition of party and appointment.
That application is annexed to the state
stop.
petition.
We have read the writ petition and the application for addition. We are of the view that Priyanka had a different cause of action and he could not have been arrayed in the writ petition. The proper remedy would have been to file a separate writ petition. However, it appears that the order of the learned single judge directing consideration
Yes.
of Priyanka had attained finality in view of the order passed by the Chairman, West Bengal Central School Service Commission on 26 September 2022. And the petitioner was recommended in an available or future vacancy as a special case, since no other candidate had approached the court. Full stop. Full stop. We are prima facie of the view that the interpretation of Rule 12(6) and 12(7) may not have been properly construed to extend such benefit. Full stop. However, having regard to the fact that the said order has been implemented, the interpretation of Rules 12(6) and 12(7) are left open. 12(6) and 12(7) of the West Bengal School Service Commission selection for appointment to the post of teachers for classes 9 and 10 in the secondary and higher secondary schools, Rules 2016, are kept open
It will be classes 11, 12. Classes 11, 12.
Here 9 and 10 is written.
So
Here it is 9 and 10. Bolla? Are left open and shall not operate as res judicata. Full stop.
now for the reason which have
9 and 10.
Wherever any objection is raised, now full stop. The appellant shall be at liberty to argue on the interpretation of the said rules in all the pending proceedings, wherever such rule may come up for consideration, and the order dated 29 September 2022 is shown as precedence, as precedence. Full stop. Mr. Bhattacharya, you also agree that this rule requires.
Yes. It may be argued not in details, not problem.
Sorry?
In future proceedings.
Mr.
My lord,
Bhattacharya
will you please to say it will be open to the parties to argue?
also has also agreed that the parties may be given liberty to interpret the said rules in all future proceedings,
Yes.
and it would not have any binding effect in all future proceedings whenever such occasion arises. Full stop. In view of the aforesaid, and for the reasons stated above, we are not interfering with the order passed by the learned single judge. However, we reiterate that the said appointment shall not create any precedence.
only one thing, the order which is under appeal being annexed at page 81, 82, there was the specific observation of the court that we have committed an error in interpreting the law.
That's
have-
why it's kept open.
That we are prima facie of the view that it requires reconsideration.
Very well.
We say
The
so.
point is kept open now. Both can argue in a different proceeding.
The interpretation of rule, we make it broadly rule 12.
12, yes, my lord. The interpretation of the recruitment rules. Lordship will say the
Also reiterate that the interpretation of the recruitment rules are kept open.
open, yes.
Kindly
Kept open.
specify rule 12.6 and rule 12.7,
Very well.
because not the entire rule.
That interpretation of rules 12(6) and 12(7) are kept open.
Lord, one more thing. It will be classes 11, 12. Even in the judgment also it is written.
It says 9 and 10. possibly.
That's probably typing error.
Rule which I have annexed possibly the wrong rule, but the language is the identical language.
No, you see here it is 9 and 10 written here. That's why
Oh, that is a error, my
it should be 10 and 11. Or
11,
and
12. 11, 12.
11,
The
12.
judgment were under appeal also.
Because the
Said-
problem is of Roman script, nothing else.
How are you now?
But I am improving gradually.
But don't leave your home.
Yes. My other friends are insisting me to appear physically. I will do after I am completely fit.
It's over, you should not.
Yes.
We are injuncting you.
My deeply obliged.
And it is not open for any further interpretation.
Yes. It's conclusive.
না ওটা 9-10 হয়ে 10-11 হয়ে যাবে। হ্যাঁ, disposal. Appeal applications and disposal.
Happy ending. I was telling my learned friend it's a happy ending because his client is also protected. We are also protected. Deeply obliged.
আচ্ছা একটা এখানে হি হয়েছে ওটা শি হলো এটা কি
What? Your client, তুই বল।
my lord might be my lord subject to correction somewhere it has been taken as he should be she
ই না সে কি বলেছি দেখে নিও।
she হবে
ববিতা না ববিতা নাকি না
প্রিয়াঙ্কা।
প্রিয়াঙ্কা she হবে সবই she
মানে নামটা তুমি এখানে কি অ্যাপ্লাই করবে
ও,
ওগুলো
ওগুলো
শিওর জেন্ডার গুলো চেঞ্জ করো এসএইচডব্লিউ আমার টাইটেল
Yes, next.
126
Appeal application or disposal.
my lord state respondents
my lord
তা ভুল করে দিয়েছি তুমি। দেখানো কি বলেছে as per the- You have not filed the paper book.
My lord, in this matter, my lord, we have prepared, but my clerk, my lord, Amol Chakraborty is sick, my lord. He is interested, my lord. He has PPI. The paperwork lying with him, my lord. I'm praying for 1 week extension time. Only 1
So
week.
it has come under the application. The time to file paper book is extended by 2 weeks from date. The matter shall be listed under the heading for hearing 2 weeks hence.
My lord, I'm grateful.
Holiday.
একটু তুমি ফোনে বলে দাও তো চন্দ্রাটা ওই শুধু বোধহয় পাঠিয়েছি ফাইলটা বোধহয় আমার কাছে আছে আমি চাপ
Item number 127.
Yes.
My lord, I am appearing for the state, my lord, Mr. Clear by Mr. Shantanu Mitra, my
Lord, after the appellate. My lord, last occasion, your lordship directed the learned advocate for the DPI to instruction into the notification memorandum dated 20th December 2013.
My lord, DPI, my lord, ANKs, their own advocate, my lord. Let them, my lord.
Vidyasagar.
Vidyasagar University. I am for the university. Yes, my lord. My lord, in our
This is annex in my supplementary.
yes, my lord, that has been annexed.
Oh.
My lord, only one thing is that our decision was taken, my lord, that is at page 5. The decision of the amendment of the statutes of the Vidyasagar University, that is at page 5, and it was amended. That means it got as. My lord, I am reading this along. Well, it really requires an interpretation from this honorable court. Why? Because it is written in the Vidyasagar University first statutes that it will be, the amendment will take effect from the date of assent of the governor. Now, my lord, so assent of the governor at page 5 was given on 26th April 2013. So, my lord, now this is upon my lord to decide. Yes, my lord. Yes, my lord.
Of this government subject to the universities amending their statutes.
Yes, my lord.
In this regard. So take effect from 3rd December.
Yes.
So once you amend it, then by reason of this notification, effective date will be 3rd December 2000. Please tell us if you are wrong. Subject to the universities amending the statute in this regard, this will otherwise, this 20th December 2013, this notification giving a retrospective effect. So as soon as you amend it, for the purpose of this leave encashment, the date relevant would be 3rd December 2000.
This is according to government notification.
Yes.
And according to our Vidyasagar University statutes, it will be taken effect from the date when the governor will give an assent to the amendment. This is our statutes.
Universities covered by state of West Bengal or universities?
State university.
State is it Vidyasagar University?
University as well.
Yes, below these amendment took place by the Vidyasagar University. The governor gave assent, page 5 of the supplementary affidavit. That is
Assent is not the everything has to be assented by the government.
but our in main statute, it is written that the amendment will take effect from the date when the governor is giving assent.
But before that, for the state university,
Milo, I've really understood what is coming in my lord's mind.
assent correct, but there are many portion of it by reason of a prior notification or it's a prior notification. You got the assent when?
Well, the assent got, my lord, on 26th April 2013, and it was informed April 2013, that is after the retirement of the principal. And this is our statutes. Vidyasagar.
So to that extent, because when statute was, it is just like giving retrospective effect to say some pensionary benefits.
Difficulty is that it's
Some
not.
pensionary benefits. For example, you see
Yes.
the pay commission recommendations. So these were given retrospective effect. That you gave a higher pay scale, maybe by reason of the recommendation of the pay scale, is an adaptation. So two things are possible, either basis before the honorable governor or with the observations of the court.
Well, I think, my lord, the observations will of the court will, my lord, redress everything. That is the conflict. That in fact, that is the conflict behind the sentences. That when the state government has given effect to from 2009.
Take instruction regard to the specific notification of 13th of December. Communicated your lordship order. Your lordship order of 17th of August 2023. What did he say? Where your lordship has specified election in regard to referendum dated 20th of December 2023.
This one.
We are communicated your lordship order to the authority council. Need a few more time for the clarification. Because the principal has retired prior to the upward that has been done. What for the DPI? Letter of public instruction.
Mr. Advocate General,
Yes, my lord, yes, come. State of General.
this problem is probably
In future, many matters.
Well, in case of another principal of the same university who retired on 31st of January 2013, he has been given restitutive effect for the purpose of
January
2013.
2013.
Before coming into effect of the lordship, this notification as the statute of the university. First statute.
Yes.
He has been given
Our
300 days
Vidyashagor
lordship.
University Act states that any amendment in the first statutes.
He has given this, but this is the
No,
document.
now he's saying that I do
But
not.
I have the copy.
I have no knowledge.
So that I can file it to supplementary evidence.
I have no knowledge.
Take this, Didi.
তুই এটা একটা supplementary affidavit করে দাও না।
Yes, if you also desire, I can file it to supplementary.
একটা ইয়ে করে instruction নিতে পারবো।
40, but I have giving you 274, but not 800 or 300.
Hateful, my lord.
Much of.
One 28.
28
IAP for the appellant.
Yes. Give us the paper.
But here, the case of the appellant is that I sought for transfer. On the
Mr.
ground.
Prasad, Mr.
Yes.
Prasad, one thing. There are two categories of transfer.
Yes,
Come to page 33.
page 33.
This is a primary condition.
Primary condition.
Second is general transfer on special ground. Now, the
Yes.
learned judge is of the view that even for special ground, you have to have 5 years.
My lord, this my special ground transfer, my lord, that grounds were incorporated, but the my lord, prerequisite has to be fulfilled. That prerequisite is at my lord, rule 3. 5 years is the my lord,
I tell you the reason. Special condition, special ground, and there is general transfer.
yes,
So general transfer said, so far as first part is concerned, that you have to complete 5 years.
yes,
You have to complete 5 years. And you may not have to show any cause. It's a matter of right. If you complete 5 years,
yes,
only thing within 25 kilometers you cannot.
yes,
So now you have been given a privilege. Now special, once you say special ground,
yes,
that means within 5 years you can apply. It cannot be 5 years. Otherwise, 5 years give you absolute right to apply. As soon as I complete my 5 years, I am eligible for making application.
making application.
Yes. So this is a general right. When you say special ground, then it may not be necessarily 5 years.
My lord,
See the grounds. For example, I think
yes, grounds were incorporated in rule 4.
I think there is an amendment to this.
Yes, there is amendment.
Page 42.
That is page 42.
Page 42, but my lord, that
Suppose I tell you, say for example, the first ground. Any of these causes happen within 5 years, then what would happen? Suppose the person is, I tell you, suppose the person is, say, located in Mayabandar. Let's give an example. And his wife is having a renal failure. There is no medical treatment available there, facility. So he has to wait 5 years so that the condition of his wife deteriorate or may not be surviving.
I'm understanding, my lord.
So 5 years cannot be, if he makes out a ground for special ground, 5 years is not the mandatory provision. So accordingly, you consider it.
My lord,
And whether you will consider it to be coming under special ground, that is up for you to decide. We are not. But 5 years mandatory period is not for, if a person is able to satisfy that the special ground exists, then the general rule of transfer that he cannot apply for 5 years gets diluted. I give an example.
yes, my lord, my lord has
Suppose
rightly
a person
pointed out.
require a bypass surgery.
Yes, yes, but the grounds should be the grounds which has been incorporated.
We are not telling any of the ground, because application was rejected on the ground that within 5 years he can make an application for special ground.
But I could not apply.
My lord, his entire prayer was, my lord, based on a representation.
No.
Let us not be play with the words. He made a prayer.
Yes, he made a prayer.
You have to consider whether he is entitled to transfer or not.
Yes, my lord.
Let us not try to pinprick, find out holes in it.
Yes, my lord, but only one thing that I want to point out, subject to correction of your lordship, my lord, these entire rules, my lord,
my lord is
We are only saying that for special ground, 5 years is not mandatory. And rest you decide in accordance with the
Lordship.
matter.
yes, my lord, but the thing is that, my lord, this rule will be operated only on the basis of if an online application will be made. That is,
Well, if it is
Keep the
not,
offline as online for the time being.
and for the timing, it is suspended. The Oshochi
So-
was suspended.
So
And my lord,
it was done my lord, much prior, before the
Yeah.
suspension.
we have heard the land council for the
My lord.
parties and read
pulling
Very
probably, my lord, there is, my lord, no such information. I draw your lordship kind attention. What happened? Petitioner stood third, respondent number stood first. Petitioner challenged the eligibility of the respondent number 6. After a long time, Honorable Court concluded, my lord, and directed the Commissioner of School Education to decide the fate of respondent number 6. But my lord, the paragraph, page 71, the Honorable Court has, my lord, made it clear, given the rider, relying upon the judgment on 2011 2 CHN Calcutta 1021, that even if the respondent number 6 appointment is found not good, then my lord, the post would be sent to the commission for recruitment under the existing rules. But that is the ratio of the judgment relied upon in 2011 2 CHN. Only I was paying your lordship's kind attention, my lord. My lord, I lost my chance in 2008. If now it is filled up by following the recruitment rules, I would be aged bar. Whether that can be confirmed by your lordship, considering the special circumstances, only that.
Yes, state. What you are handing over?
My lord.
You will not speak. You'll hand over documents only.
My lord, it is a process of 2008, my lord. The petitioner came before your lordship. He is the appellant, my lord. He is the third impanel candidate, my lord.
The third impanel?
Yes, my lord. And second impanel candidate died, my lord, long back, my lord. And I have given the approval of appointment panel and also the certificate.
If my age is condoned, considering the special circumstances.
If you are selected.
Yes, definitely. I want to appear in this
What do you
selection
say to that?
condoning the age only, nothing else.
What do you say to that?
It is.
It is what not? Possible, impossible?
It is impossible. It is 2008 selection process.
Decision is of 2023. That's the reason.
Process
The
is
petition,
Can we go beyond the judgment of the 3-judge bench? We cannot.
no, 3 judges bench has not touched that word. 3 judges bench, even 3 judges bench matter. The ratio was, the reference was on 3 points. Whether Vishweshwar Rao is applicable or not, whether if the Vishweshwar Rao is applicable, after cancellation of panel, and now second was whether
Suppose if he is found to be eligible,
otherwise.
there are decisions that
Jammu and Kashmir PSC, I didn't bring that.
In appropriate cases, if you found it to be appropriate, then in appropriate cases it can be condoned. What do you say? It is found, because you see he was third impanel.
Third impanel.
Now first has,
Given the appointment. He is the respondent number 6.
he has been given the appointment.
Yes, he is working.
He is working. Now it is found that
Last 15 years he is working.
yes,
Empanelment of first is bad.
the first is bad.
Yes.
If.
What is it?
If it is bad,
My lord.
If it
if it
is
is bad,
if
then
it-
it has to be balanced.
Yes. Only that I'm
Lay down.
lots.
Not information. Lord, it would be
They are not
happy.
going by information. The record will speak for itself.
Yes, no, they are
Don't
relying.
be shy.
No, I'm not. Lord, they are relying upon information.
Forget about what they rely upon. They will rely. We are not relying upon anything, excepting they will rely upon all the documents. That's all. Lay down.
card, it is at page 74. I'll just come to the facts. May I state the facts in brief manner?
Stated documents. Oh, yes, whether you have received it or not, that is in doubt.
And
Whether these were received it or not, that is in doubt. They have come up with a plea that it is a fake.
they have come up with a plea that
It's a fake.
it is a fake document. I have taken an exception stating that I have downloaded it, and my only prayer is let an expert be appointed. Let that expert
What is
see.
this writ proceeding? You file a suit, find out.
I will kindly appreciate something. I have taken out a document from the website of the respondent number 4. I have stated that on record. Today, challenging the authenticity of the document is very easy. I can say that this document is fake anytime.
Not go into that question in this writ proceeding.
I will kindly
But they have
appreciate that
They have given some explanation at page 55.
they have. I have also given some explanation
Yes,
at
so
page.
not a proper 65B certification, other things, evidence that will not go into that.
I will kindly come to the impugned
up.
order for once. For once, my lord, will kindly come to the impugned order for once, my lord.
You have read it.
But it's
That is
the impugned order says that that I have not even rebutted. That is probably not true.
The appeal is arising out of an order dated 10th April 2023. In a writ petition,
I will kindly appreciate the plight of the petitioner. He has appeared and he is not even getting anything, my lord.
appointment letter to the post of teacher in primary school in favor of the writ petitioner. Dispute arose with regard to authentication of the application.
Of the not of the application, the authenticity of the screenshot which I have taken out. They have disputed that.
Authentication of the screenshot
of my grievance status, my lord.
Screenshot of the grievance status report. The school education department filed an affidavit before the learned single judge in which the following facts have been stated. Paragraph 4. The Joint Secretary Elementary Branch who affirmed the affidavit has specifically stated that the allegation is totally false. False, full stop. The respondent filed an affidavit taking exception to the said report and has called for an expert's opinion to settle the dispute. We are of the view that the nature of the dispute cannot be conveniently decided in this proceeding. Moreover, in view of the contention raised by the on behalf of the school department, on behalf of the education department, we are not inclined to exercise our discretionary jurisdiction. The appeal stand dismissed. However, the appellant may take appropriate steps in accordance with law.
Will kindly give me liberty to file this suit.
Yeah, we are of the We are of the view that the said issue cannot be conveniently decided, right? They conveniently decided that this proceeding
Absolutely failed documents. No fake. এরকম কোনো বোর্ডের ওয়েবসাইটই নেই। ওকে অ্যারেস্ট হয়ে যাবে আর মামলা করতে বারণ করো। কি এটা ওয়েবসাইটই নয় এটা না পুরো 2 নম্বর।
This order, however, shall not prevent the appellant
না না একদম বলো না অ্যাডভাইস করো না বেকার ছেলে
uh, to prove its claim, otherwise in a proper court of law.
গিয়ে বুঝামুঝি করে দেবে।
That has given me liberty to.
The challenge is 65B and we produce the
He
evidence.
is always there. My lord can remember when your lordship was sitting in court number 12. My lord, we submitted, my lord, my lord, we uploaded the panel and submitted, my lord, we are forced to, my lord, remove the panel from the website because, my lord, the fake website was created. Now, this is the result of fake website.
Yes, next.
Result.
31, I am for the appellant, my lord. In this matter, my lord, the learned advocate Sarbar Jha is the appear, my lord. He is Sarbar Jha. He is appear on court number 14, my lord. Kindly take it, my lord, pass over, my lord. I pray for pass over.
For the state.
Yes, my lord.
Why did you call all the parties and decide the issue? Because it's a dispute between the stepmother and the stepson.
Yes, my lord.
Now, you can always hold an inquiry to find out whether the stepson is really looking after, because she's otherwise entitled. You are not saying they're not, you have not rejected actually.
My
You have
lord,
said that
my lord, mother of the stepmother of the petitioner is also entitled, and the stepson is also entitled.
stepson, it is being said that not staying with the mother and not looking after the mother.
My
stepmother.
lord.
If the fact remains that, then obviously stepmother will have a better right.
My lord.
So you take a call on that.
My lord, that has been tried. My lord, kindly come to
No,
paragraph.
you call it. If the stepson doesn't come, you decide in absence of the stepson and on the basis of your guidelines.
My lord, kindly come to page, my lord, this number.
But have you served all?
Yes, my lord, I am served.
Page one, please. My lord, kindly come to
But
last page.
you are required to make this Humayun party who is, you have not made him a party.
Not made, my lord, because, my lord, in writ petition, he was not in party, my lord. So I am not.
No, but you have to make him a party because you are seeking a relief against him as well, because you are saying that he is not cooperating.
Yes, my lord, that is, my lord.
That is, who is that? Sheikh Shahjahan.
Shahjahan is the stepson.
Shahjahan, my lord. Yes, my lord.
Shahjahan is the stepson, my lord.
Shahjahan.
Shahjahan is the stepson.
Yes, ma'am.
Take now.
My lord, kindly come to answer P3, my lord.
We feel that in deciding the matter, we feel Yes.
My lord, item number 132, my lord, Mr. Dheeraj Trivedi and Susmita Saraswati appearing for the respondent ISI, my lord. My lord, I'm paying for one day accommodation, my lord. My lord. I appear for the appellant.
What does this matter? The council.
Well, I'm having a leader, my lord. Mr. Shakko Sen is appearing.
But there's no scope for an interim order. The appeal has to be heard.
No, I'm only playing for not today. Since
No, but there is no scope for an interim order to be passed.
no, very well, next day on, any day next day.
What do you mean by very well next day? There is no scope for an interim order.
No, I'm only praying for not today, that's.
Stay down.
My lord, if you should kindly pick after, can it be fixed after 5th of September, my lord? Because my lord,
Adjournment is prayed for on behalf of the appellant. First up, the Learned Council for the respondents have prayed for adjournment till 5th of September 2023. Let this matter be listed on 6th September 2023.
deeply obliged. My lord, affidavit service we kept with the record.
The affidavit service is kept to the record.
Grateful. my lord.
Next.
And it's
Yes, yes.
133, my lord, I am here. My lord, I have challenged. Sorry.
Yes. Yes.
But I have challenged a judgment and order dated 26th April 2023. Well, may I just place the
Yeah, that's it. Respondent.
state? Oh, petitioner to solve করেছে।
That's 60 years benefit. That is the issue.
Yes, but they are not entitled, my lord.
Why not?
Because, my lord, there are three reasons. First, they are not formal teachers. They were not engaged in any formal schools. Their scheme was stopped in 2012. Some incorrect facts were placed in the writ petition that they continued for after 2012. The term.
When the notification came into operation, they were not doing their work.
No, no. They were excluded. Since inception, they were excluded. 9th June 2010 circular, my lord, only extended benefit to para teachers.
Is there any break-in period or lack of continuity?
My lord, after 2012, my lord,
Please answer.
yes.
Is there any break-in service or other lack of continuity? If it is not, then they are entitled.
My lord, from the very
After all,
inception.
they are part of implementing the Right to Education Act.
Now, there are two things, my lord.
And many matters we have granted that.
Well, there are two things.
Provided there is no break or lack of continuity.
My lord, when in 2012, my lord, their term expired.
Your notification is 2011.
2010.
Sorry,
2010 notification, yes.
So 2010 gives
The
them
2010 notification, my lord, did not give any benefit to this group of teachers. They are not teachers, they were tutors. And after
they are all for the purpose of implementation of Right to Education Act.
yes, but the in terms of the Right to Education Act, my lord, they cannot qualify. We extended benefit, my lord.
They are basically, in the sense, para teachers. Basically,
no, they are not
para teachers in the sense that they say auxiliary teacher.
My lord, I will only indicate one thing. My lord, all para teachers were engaged in formal schools, recognized schools.
Yes.
My lord, they were engaged in
for the dropouts.
For dropouts, yes.
Right.
Now,
but if they are doing it, part of it, Then why they should be deprived?
My lord, for three reasons. First, the entire fund we receive from the central and the state government, the fund is limited. Now, if we do not require them, there are three things, my lord. I shall show from the RTE Act and, my lord, three notifications of the state government. Two notifications which were not challenged have been set aside, which were not challenged. Three things, my lord. First thing is, my lord, when these
No, is this person doing his job? Is he continuing his work?
No. After 2012, the entire fund, my lord, stopped giving funds, and the term, my lord, mentioned in the agreement expired. Then when they accepted the agreement, term expired. Thereafter, my lord, after enjoying that period, after a lapse of 2 years, they moved a writ petition challenging that said agreement, which they signed. The term of one of the conditions in that agreement clearly mentioned that their extension will not be done after completion, after expiry of that term mentioned in the agreement. They accepted that term. They enjoyed that 2-year period of service. Thereafter, my lord, after 2015, they moved that writ petition, challenging the same agreement which they signed.
But you see, there's a direction which says the state respondents are directed to pay the area honorarium.
Yes.
Which is admissible to Shiksha Mitros, treating his engagement as a continuing one. When it was
After 2012, my lord, there was no question of continuation. That is, my lord.
But they filed the writ in 2022.
The first writ petition was filed in 2016. This honorable court, my lord, directed the state project director to consider their representation. That was, my lord, by a reasoned order, was rejected. Then the second writ petition was filed. That was allowed with all area. There is no question.
In 2016, they are not in employment since when?
2012 onwards.
You are appearing, Mr. Bushmalli.
Yes, for the state lordship.
The writ petition is not appearing, my lord.
We are supporting Mr. Mukherjee.
No, very well. So you should sit here, in fact. No, it's fine. But who is for the writ petitioner?
My lord, Mr. Shamimul Bari, my lord, I have served, my lord.
Shamim Ahmed.
Shamim.
এটা কি তুই তো? হ্যাঁ, এটাই আমার। That's strong.
Has he received?
Yes, received. I can give a notice, my lord, to Mr. Ahmed, my lord.
The writ petitioner is not represented. In spite of notice, the writ petitioner is not represented. Let an appropriate notice be served upon. Who is appearing? Mr. Shamim Ahmed.
Shamim Ahmed, my lord.
Upon Mr. Shamim Ahmed, advocate. Representing the writ petitioner. In course of this week, with the intimation that the matter shall be listed after 1 week. Shall be listed after 1 week interview. In the event the writ petition is not represented on the urgent date, stay application may be heard in absence of
করিস না কেন?
Yes, they want the second half year question. I got seven page নিচে রাখো না। তারপর তো সঙ্গীত জাজ তখন আড়াইটার সময় চিফ জাস্টিসের সঙ্গে
ও বেঞ্চ হওয়ার চান্স খুব কম।
হ্যাঁ উনার আড়াইটে থেকে আর হবে না
চলো এগুলো নিয়ে নে, হয়ে গেছে আর হবে না।
সেকেন্ড হাফে ইভেন্টস আর করেছিল ইভেন্টস 41 আমি দুটো ফোনের তো আড়াই
বললাম
কন্টিনিউ চলবে তো কেউ বলতে পারবে না কেউ বলতে পারবে না
Observation in page 42, how the contempt lies.
You know, that, your lordship, this affidavit which was filed before your lordships, when your lordships were taking up this matter, we have seen this. This was also before the trial court. Now, what happened is that this affidavit is not correct. I don't want to blame because the other side advocates are
We
there.
have said that
Your lordships have said that. Your
the
lordships have
amount received
observed.
by the petitioner does not reflect the actual payment receivable as subsistence allowance in view of the revision of pay scales during the aforesaid period. In this proceeding, we cannot adjudicate the dispute. We cannot go into the question as to whether. Now, similar thing you have asked for contempt.
Yes.
So how
Now,
can we?
your lordships, if the person is saying something which is not correct, which is a lie before the court. Now, my point is, Miller, contempt
They have calculated on a certain basis.
they have shown no calculation before this court. They've just filed an affidavit saying we have paid this and we have paid this.
Yes.
But it does actually there was no revision.
But if you are not accepting it, your courts is reopened. You can file a writ petition.
If your lordship grants me that, I'll go in.
That's already there.
If because of this observation, I had to come before your lordships. Because after this observation, I can't file a writ petition.
We cannot go into the question as to whether the said amount actually represents the entitlement of the petitioner in terms of the order passed by the learned single judge. We only record our concurrence with the finding.
Yes.
That's all.
Because if your lordship, now if I try to open this, this will be staring, your lordship's observation will be staring me right on the face.
Observation.
It appears that the bank has paid the amount.
We have recorded your submission and said this submission we are unable to go into in this proceeding. We have said so.
Then if your lordships could, because in the writ petition, this will be a stumbling block for me.
Okay.
If your lordships kindly clarify. Please.
Applicant of contempt application is appearing for the first time, Your Lordship.
What is the contempt?
Your Lordship, the contempt is at page number 75 of the contempt application, 68 of the application, Your Lordship. The operative portion is at internal page 7.
Acts of contempt কি আছে? What are the acts of contempt?
Your Lordship, they have not disbursed the amount as elected by my lord. Your Lordship, after the passing of this order,
No special petition?
yes, these central government, the Union of India has preferred an SLP, but till date there is no stay order, Your Lordship.
But then if the SLP is there, we cannot touch it. The SLP is there, how can we touch it?
But Your Lordship, the SLP was filed on 4th February 2022.
Yes.
And they are taking time over there, Your Lordship. My client
You
is
oppose that, but how can the contempt would lie? SLP was not admitted.
yes, sir, on me admitted, but
Admitted?
yes.
If the SLP is admitted, how could you file? Where is the order of admission of the SLP?
Your Lordship, at relevant, I do not have it today, Your Lordship.
Then you say it's admitted?
As per my instruction, it is admitted.
Order, not a partner. Where you have disclosed SLP?
SLP, Your Lordship, at page 18 of the application, para 17.
No, document you have disclosed.
No.
The order in the SLP. Then SLP তাহলে কি করবো?
Your Lordship,
If it is admitted, then we
you will, Your Lordship.
Who has filed the SLP?
The Union of India, Your Lordship.
SLP করেছে বলছি, admission stay নাই। There is no stay. Are you sure about it?
Sure, absolutely sure. Till date, no stay, Your Lordship.
This could have Yes, call the list.
Now for the respondent.
Virtually asked. Oh, they gave me a application. Yes. Yes. The last one. Yes, you start. Conclude yourself.
The marriage in these proceedings was held on 18th February 2005. The son born on 25th May 2007. And the respondent left the premises with the child on 3rd May 2009. The suit was filed by the respondents on 15th February 2011. On 14th September, the appellant entered appearance and filed the written statement. Now, thereafter, the appellant avoided, although my client lead evidence, but she has not been cross-examined by the appellant. Thereafter, on one ground or another, every time he is taking time, as he is doing in before this honorable court. She was doing the same thing before the learned trial judge. Now, the order sheets is annexed with the application for stay. If your lordships kindly see page 119 of the stay application, the entire order up to the date of passing of the judgment is there. Now, your lordships kindly see. Each and every occasion, he is taking time. Now, if you lost kindly see page 125.
So what do you say on the merits that whether suppose you are not cross-examined?
Yes.
Still the law says that you have to prove your case.
Yes.
How you have proved your case?
Now, kindly see the kindly come to the order. The order dated 21st March 2017 at page 133, 135.
Yes.
May I read,
today is fixed for further cross-examination of PW. Both sides filed Hajiras. PW1 is further cross-examined in part, and on the prayer of the learned lawyer for the petitioner wife under the petition ground stated therein, a fixed 15 May 2017 for further cross-examination of Monojit Basu husband. PW then 15th May. Parties file Ajira. PW1 is further cross-examined in part and deferred on the prayer of the learned lawyer for the respondent. Fixed 14th July. Now 14th July, both sides file Hajira. Petition is being filed on behalf of the petitioner, pays for time on the ground of our learned lawyer. Heard both sides. Fixed 10th November 2017 for further cross-examination of Monojit Basu husband. Then today is next order. Today is fixed for further cross-examination of Monojit Basu. Both parties are present by filing Hajira. Respondent files a time petition along with discharge summary on the ground stated therein. Copy served, objection raised and considered. Prayer for time is rejected as per.
She leave, Mr. Roy.
My lord.
When did your client leave the matrimonial home?
My lord, she left the matrimonial home on 3rd May 2009.
3rd May 2009.
My lord.
When did you file the suit?
My lord, the suit was filed on 15th February 2011.
Within 2 years.
My lord.
Within 2 years.
Yes. Yes.
Where is the evidence testimony of your client as PW1?
103.
Evidence so much affidavit. এটা হচ্ছে 103 হচ্ছে সেই custody 26
Evidence এর উপর আলাদা।
426 এইটা এখানে আছে আরো কিছু for the 155
The affidavit in chief is there, 109.
109?
109.
No, 109. That is the testimony of the OP1 in the miss case under section 26. Perhaps you come to 156. You come to 156. Perhaps it is there. 156. Of the stay application.
Yes, my lord. 150 examination in chief of the petitioner.
Yes. Your client is the petitioner.
Yes.
She was the petitioner before the trial court.
Yes.
This is her statement under order 18.
The affidavit in custody the respondent. No, it is affidavit in chief in section 13. Now, the affidavit in chief, all these statements mostly that has been made in the application under section 13 has been reiterated in the affidavit in chief.
accept করে নেন right now process আর যদি written statement যদি খারাপ কথা বলি তো পরে confirm with allegation করে থাকে written statement what was said yes.
My lord, my submission before your lordship is this, my lord. The suit was instituted on 2011. Now, my lord, I am left the premises in 2009. Thereafter, I don't have any relation with this husband. In fact, my lord, the husband, when appeared before your lordship, also, my lord, opined that he also do not want to stay, but my lord, he wants a compromise. That submission was made before your lordship. My lord, for the last, my lord, 12 years or more, my lord, we are residing separately, and my lord, there is no matrimonial relationship in between the parties for the last 12 years. And my lord, the husband, my lord, the conduct of the husband shows that, my lord, he do not want to, my lord, live with me. My lord, the conduct before this honorable court also shows, my lord, he is avoiding this my lord, honorable court, and my lord, not paying anything, not to me. I am not asking for anything, but my lord, to my child also, he is not paying anything.
That's really the point. Yes.
My lord, practically, my lord, the marriage has been broken, my lord, irretrievably. So, my lord, I want, my lord, the order of divorce should be maintained, because, my lord, there is no love and affection in between the parties. My lord, I have asked for a book. My lord, recently the Honorable Supreme Court says, my lord, if these sorts of litigations are, my lord, continued, then, my lord, that will be a cruelty to the parties. And, my lord, Supreme Court, my lord, directs that the marriage should be, my lord, dissolved.
That was another
142. My lord, that is under Article 142.
the judgment of Justice Sanjay Kishan Kaul.
Yes, 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 yes,
Range of pricing.
yes,
It's under 142.
yes, my lord. That's under 142. But, my lord, the proposition, the principle, my lord, I want to say, my lord, cite before your lordship, my lord. No, my lord, this is a judgment of Justice Sudhanshu Dhulia, my lord. This is, I have one copy, my lord, kindly have.
করে তো সেটা একটা সমস্যা
My lord, I shall, my lord, make it Xerox and, my lord, hand it over to your lordship's officer. My lord.
এই এটা একটু দিই
Is anything else?
Well, since my lord, the appellant is not appearing, so my lord,
What do you say about the custody matter?
my lord,
Regard to the custody matter, what do you say?
and the custody is with me, my lord. The child is residing with me.
Right now.
No, my lord, 2007, the child born, my lord, 16 years. Just crossed the 16 years of age, my lord, in May.
Your discretion. Martha Chitha, Hon'ble. Hello. Hmm. Appellant is not present. Stop. Appellant. With the clear indication that the applicant shall not object. Those who are earlier ordered that the applicant shall card all so the result. Here is complete. Start the applicant inspection of the LCM. Start. You also indicated in the order that the applicant is not present. Suppose of the hearing the counsel for respondent by and respondent by and on the basis of appellant was the appellant contact for the appellant is unsatisfactory. The appellant had delayed hearing of it. Have given enough opportunities to the appellant to address us both in respect of steps of court's proceeding aspects. Right of the ample opportunities to the appellant. It seems that the appellant is not interested. Proceeding here. However, as a last stop, we have heard
No,